a conversation that I've been waiting to have with my attorney, who we're now working together on a project with this, which is super exciting. But so I'm here with Owen Seitel of Crown LLP. And Owen, I'm going to go ahead and let you introduce yourself, and then we'll get going.
Sure. Thanks, Eric. Yeah, and we've been trying to set this up for a while, so good to be here.
Yeah.
So, as you said, my name's Owen Seitel. I'm an attorney. I'm the co-founder of a law firm called Crown LLP. We're a boutique intellectual property, business law, entertainment law firm in San Francisco, California. So I provide general counsel services and specific intellectual property counsel services um, to anyone that's focused on entertainment, media, sports, the creative industries broadly, and that creative industries concept is getting broader on a daily basis. So all the creators out there, those are the kind of people I work with. So while I work with just about any type of business, my focus is on those for whom creation, protection, exploitation of their intellectual property is the focus of their business. That's how they make money. So I work with creative agencies, branding agencies, people like you, Eric, production companies of all sorts, whether it be in music, film, live event, so on, apparel companies, and individual creators of all sorts producing content for their own exploitation. So that's, everything from visual artists, authors, athletes, screenwriters, social media influencers, and like I said, just about creators of all sorts. So
My
that's
God.
what we do. And yeah, we're Crown LLP, and you can find us at www.crownllp.com.
Sweet. No, I honestly, the breadth of what is considered creative at this point really is getting just wider and wider all the time. I'm interested to know why. Was there a specific point in your career that you decided that you wanted to work with creatives, or was that always a thing? And specifically, why creatives for you? I don't even think we've ever talked about this.
Yeah. So yeah, I fell into being an attorney in the entertainment industry, which drives my colleagues crazy because so many of my colleagues that are entertainment lawyers, that's all they wanted to do since they were, 5 years old. For me, I had some friends. This is going back in the 90s, so I'm going to date myself. I had some friends who were in a band and they got offered a record deal. And they asked me if I could help them out. And I said, look, I have no idea what I'm doing, but I'm going to figure it out. I'm going to help you out because that sounds a hell of a lot more fun than what I'm doing at the time, which was just representing insurance companies and trying to make sure that they didn't have to pay out money to people.
Yeah.
So I figured it out and I helped them out and they got a record deal. And as is often the case with a relatively tight community of artists, entertainers, anywhere, they spread my name out pretty quickly. So within 6 months, I had done, at least a handful of other record deals. I started representing visual artists of all sorts. And lo and behold, Owen's an entertainment lawyer. So that's how I got into it. I've certainly always loved all kinds of art, music, and so on. I just never really thought there was a viable course for me to make money as a lawyer in that, unless I'm going to be in Beverly Hills or something like that. But like I said, I fell into it. The opportunity arose. I jump on it. And that was a long time ago. And that's what I've been doing ever since.
Yeah, I think that's fantastic. I think there's I don't know if it's a point of confusion or just not just ignorance or just not having the knowledge. So what is the difference between, obviously there are plenty of different attorneys, right? But what's the big difference between somebody, like I don't know, mom and pop law firm in like small town, wherever, versus, entertainment, intellectual property attorney? What's the big difference there?
So, intellectual property is kind of the umbrella under which entertainment largely falls. So, first and foremost, you have to understand intellectual property. And what are we talking about there? We're talking about copyright, trademark, right of publicity, and patents. Now, I don't do patents. I leave that to the more scientifically inclined people, but I do work extensively copyright, trademark, and right of publicity. So, yeah. That's what I do. I understand the law in that area. That's, that's the work I do every day. So, I don't do insurance coverage. I don't do personal injury. There are plenty of people that do that. We all, as attorneys, we kind of find our lane eventually. And I found my lane. So, yeah.
Okay. Yeah. So intellectual property being that big umbrella, which makes sense. So when it comes to creatives, and this is the conversation that you and I, obviously being a creative, I'm, trying to learn this stuff as I'm going. And I've started to talk to other creatives about this kind of same thing. I think they're a big point, no matter where you're at in your career. But when you're talking about having like a solid contract in place, what specifically makes a good creative contract?
Sure. Well, look, first and foremost, any business contract has to have some core elements, whether it's creative contract, whether it's a contract to sell a piece of, property, whatever it may be. You need to clearly identify the parties. That sounds obvious, but you'd be shocked at how often that is not the case in a contract that I look at. You need to, clearly state what the term is. In other words, when do things start and when do things end? And if there's not a clear end date, how do one or both of the parties then put the contract at an end? That needs to be clear in there. There needs to be consideration. And what does that mean? That's kind of a fancy legal word. What is the exchange? One party's going to give money in exchange for receipt of a logo, so on and so forth. So the exchange needs to be very clearly stated. Who's going to get what for what? What's given back and forth. And then, beyond that, when we're looking at intellectual property, entertainment contracts, then we need to get into, what is the actual intellectual property that's being created? Is something being created? Is it, is it being created from a new, or is this kind of a rework of an existing piece? And really crucially, who is going to own that creation? Is it the hiring party that's going to own it, or is it the party that is taking pen to paper or clicking the shutter on the camera, or whatever it may be? That needs to be crystal clear, because that's where the disputes arise. Without a contract, it's assumed under copyright law that the person that takes pen to paper and does that drawing or clicks the camera, it's assumed that that person is the copyright owner. So that's the default. And unless that default is addressed in a contract, that's the way it's going to happen. So quite often, if that's not addressed, the party that just paid for something and thinks they're getting everything, they're really not getting everything, because they did not explicitly say so. And this is where we get into the concept of work for hire, which is probably a whole different discussion, and that's a whole can of worms. But that's how we clarify, when we have a contract for creative services, there's going to be a deliverable of some sort. Who is going to own that deliverable? Do they get full ownership? Do they just get a license? Can they, and for a license, that will then delineate how much time can they use it? A year, 6 months, 10 years, whatever it may be. What's the geographical scope of that license? Is it just North America? Is it the world? What is the length of that license in terms of time? Again, it could be perpetual. It could be for the length of the copyright, which is quite a long time. So these are the kind of issues that really have to be drilled down on when you're doing a contract in the creative industries or the entertainment industry more broadly.
Yeah, that's really interesting. I actually didn't know that the copyright would fall to the person that actually did it. I guess I'm always in the mindset of thinking that somebody else always owns my work. So no matter, or at least the person that has the money, right? Because I think it's generally like creatives, especially if you're not in some, high level entertainment position, or you don't have a massive agency or something, right? Generally we fall prey to the client, because they're the ones that generally have the money to go, well, no, it is mine. And then have, be able to put the legal action there. Right. So adding to that, what are some of the things that you generally don't see in creative contracts, but you wish you did see beyond the ownership, beyond that? So big things people wouldn't even think about.
Ownership is the big issue. Is there a license? Is there ownership? So on and so forth. The things that I like to see in a creative contract are, clearly we need to delineate what the deliverables are. And try to give a date upon when that deliverable will be provided, so that we have, clarity in terms of what the steps are in production under the contract. When I'm representing a client, typically some of the things I like to see in a contract are a dispute resolution clause. If there's a dispute between these parties, how is it going to be dealt with? If it's not addressed at all in the contract, the assumption is that either party can run down to their local courthouse and file a lawsuit and deal with it that way. And that may be just fine. But if you want, quite often in creative contracts, you'll have one party that's got a significantly more leverage than the other. The ability
Mm-hmm.
to, they have money, they have the ability to pay attorneys, all that kind of fun stuff. So what I like to see when I'm representing a party that perhaps does not have quite the leverage that the other one does is I want to see a venue provision and a choice of law, because I would like to make it clear that if there is a dispute, that dispute is going to be resolved in my client's backyard, not across the country somewhere where we have to go, hire an attorney over there, fly across the country, all that kind of stuff. So I like to
Yeah.
see a venue and choice of law provision that clarifies where a dispute is going to be resolved geographically. Then you can also, there are options for example, an arbitration provision. You could say, you know what, we're going to forego court and instead we're going to arbitrate this. And that's fine. There's an upside and a downside to arbitration, and I'll usually go through those issues with the client before sticking an arbitration clause in a contract. But again, where's that arbitration going to take place? I'd like it to take place in my client's backyard. So that's that kind of goes. And again, and similarly, choice of law. I mean, you, Eric, or people in your situation, you may have clients entirely across country. In my
Mm-hmm.
backyard here in California.
Yep.
But what we want to do is want to have any dispute resolved in your area, and we want your local law typically to apply. So we want that to be clear in the agreement. The other area that gets a lot of attention, at least from me, and I see gets really short shrift in general, are the representations and warranties. So typically, if you are providing something in a contract, you're going to make various representations and warranties. For example, in a creative services contract, it's very common that we'll make a representation or warranty that what we're providing is original. We didn't go out and copy it from somewhere, so on and so forth. So we can say that it's original, which means that, we don't expect a third party to come out of the woodworks and assert a copyright infringement claim. So that's fine. Where things get a little bit tricky is where we have broad language in a rep and warranties clause that's something along the lines of all intellectual property, what we're providing to you is not going to infringe upon any third party's intellectual property rights. Well, when it comes to trademarks, you really can't do that because trademarks are different than copyright. Trademarks is a source identifier of where goods and services. So when you see the Nike swoosh, you know that that's a Nike product, and you conjure in your mind as a consumer what the quality of that product is. But trademarks are very regional and territorial. So, one party could have a trademark for a lawn mowing service in LA, and another party could have the same exact trademark for a nail salon in Florida. And as long as there's no consumer confusion between them, they can continue to coexist. So that's, in order to determine whether a mark infringes upon a third party right, it requires an attorney typically to go through a whole process, a whole search process, make a determination of whether the landscape is clear for that use and so on, which is why, I see a lot of broad statements of that intellectual property doesn't infringe on third party rights. And I always cringe and I always make a change to that because as it relates to trademarks, we can't say that. Only an attorney that does a full trademark search can say that. So we have to be really careful of that.
Okay. Wow. I mean, obviously all of this stuff is like, creatives are generally right brain, left brain. This is all kind of in the left brain category. I have a couple of questions kind of coming off of this now. So when should someone consider using a contract? Like at what point do you say, like, is it a dollar amount? Is it a, like, I feel comfy amount? Is it every time? Like when should, and this is from the perspective of like, let's say like super small, nobody freelancer, right? Like somebody that's either just starting out, right? Like where do we put the threshold of needing a contract and what does that really need to look like? Is it a massive document or is it a single page something? Like what's the recommendation on something like that?
Right. Well, look, it's a self-serving answer, but always,
Sure.
but
Yeah.
I understand what the realities are out there in the marketplace, and not everybody can go and hire an attorney to, fight their fight for them.
Sure.
So, certainly, when you reach a certain dollar amount, you want to have a contract in place. What that dollar amount is, I mean, that's going to be different for different people. So, there's that. Anytime that you're exchanging intellectual property, that there's going to be some creations are involved that are going to be exchanged, I think you need to have a contract, because again, we get into these ownerships and rights issues as it relates to what is being conveyed. So
Hmm.
I think anytime you have that as a creative, you need to really protect your creative output. And the way you do that is in a contract, in a good contract. So it's very clear between the two parties, because it's in writing who's
Hmm.
going to own it, what are the rights the parties have to use this particular piece of material going forward. So anytime that you have that kind of exchange, I think you need a contract.
Okay. Well, and then because, some people can hire an attorney, some people can't. What When somebody's ready to, like it took me a little while to be ready to do it. What would you say they need to look for in an attorney beyond, my recommendation is always, if you're a creative, it should be intellectual property, entertainment, somewhere in there,
Right.
just because you know the specifics. But as far as just being able to select an attorney in general and be able to pull one out of a pool, what are your recommendations there?
Yeah, well, certainly for creatives, you want to find an attorney that has expertise, a level of skill in the area of copyrights, because
Mm.
that is the vast majority of what you're dealing with. So, clear understanding of copyright, so on and so forth. That is across the board. Then you want to, find somebody that has a skill set, the ability to actually draft contracts that are understandable. So,
Yeah.
if it's not, you could certainly ask to see other works, or, for example, if you go to our website, you'll see how, what our writing style is, and you'll see how clear things are, and maybe reach a comfort level there. So, I think, yeah, getting back to, what you're looking for. And then if you're in a particular niche in the media slash
Uh,
entertainment industry, you want to find somebody that has an understanding of that ecosystem. So, I do a lot of work in the music world. Well, in most popular music, recorded music, there are two copyrights in a piece of music. And so you have to have an understanding of that if you're going to do sampling, or if you're going to license your music, what exactly is being licensed. Likewise, if you're in the film industry, there's a whole other ecosystem there. There's a way things are done. Option agreements are crucial to the film industry. If you're representing a screenwriter, we do option agreements all the time. So you just have to have an understanding of the particular ecosystem that client works within, and of course, an understanding of the general law that applies to that area.
okay. Well, now that it's almost becoming like, I don't know, I think with most industries at this point, everybody feels like AI is sweeping in to take a lot of their business away at this point. What are your thoughts on AI, number one? And what would you say to a lot of the creatives that are out there that are using AI to draft their contracts at this point?
Yeah, I've been playing around with AI.
Hmm.
It's not there yet. Although, I know months ago when I first looked at it versus like last night when I looked at it, I could see that there's some learning going on in that machine out there in the cloud somewhere. AI for drafting contracts, it's just not there yet. I think it will be at some point in time. When that is, I don't know. But the crucial element, whether it's now or when AI gets a whole lot better, is the quality of the prompts you put in. So, if you're not, and really that, so you have to kind of go into the AI model with some knowledge, with some buzzwords, with, in terms of what you're looking for. And that's where people are going to get tripped up. So, AI's there. I think it's going to get to a point where it drafts some pretty good contracts. Does it get to a point where it drafts really good contracts in specific niche areas? I just don't know. And again, it's going to depend upon the prompts. One thing that creatives need to be aware of is that, the Copyright Office came down with a policy and said AI generated works are not capable of copyright protection. because only a person can get a copyright. So if you are using AI to generate, images, whatever it may be, if you let it be known somehow, or if it becomes known somehow that you used
Which,
AI in generation of that works, you may not be able to get a copyright in that,
yeah.
which is kind of a core to what you creative people do.
Yeah, that I had no idea. I mean, that makes total sense considering they don't have any place they can't pin anything on anything. They're pulling it from, information from everywhere.
Yeah, and there's no person. There's no
Yeah.
person. It's clear that only a person can get a copyright. There was a case a couple years ago, famous case where a wildlife photographer shooting photos of monkeys and so on in the jungle. The monkeys could see. They're smart. They see what he does with his camera. So he just set a camera up and left the jungle. And one of the monkeys came by and took a selfie. And they tried to register the copyright for the monkey. And the copyright office in the court said, no, monkeys can't get copyrights. So yes, he did pull the clicker, but Mr. Monkey can't get a copyright. So it's just conceptually the same as AI. There's no person, a person needs to be behind it.
Yeah. And I think the interesting thing is obviously, when you're starting out, I did the same thing. I did the AIGA contract mashup that you were like, I hate these. And, ripping stuff off of Google and whatever, you do what you need to do. But, I think there's a big thing with AI and creating these, right? Like you don't actually know, if you're not an attorney, you don't actually know if it's viable or enforceable or what a period or a semicolon or a comma or whatever does to a sentence or a clause or whatever. So that's always my thought whenever, I'm talking to people that are, trying to use this and kind of get around things. I mean, yeah, obviously I guess everything will be there someday, but for now I would much rather see a professional look over everything.
Yeah, no, I don't think, I think we're still going to be employed for a little bit longer here.
I would hope so. Yeah. So talking about, you actually gave a really good segue. So you just gave this example about the monkey. I'm interested, obviously not naming any names, but one of the more severe cases you've dealt with, maybe where a creative wasn't protected and kind of what the cause, like how you got around that or what they had to just deal with because they weren't.
Right. Well, the common scenario that is not a good news scenario is infringement. Copyright infringement. So, my got many scenarios where a client will create something, a photograph, whatever it may be, and then they go out in the world and say, wait a minute, that's my photo on that billboard up there advertising, skin rejuvenation or whatever it may be. So, that is a common one. So, one of the things, if you're a creative and if you're creating content that is capable of copyright protection, one of the things you need to know, and we'll go into a little bit of law here, is once you put down your original work on a tangible medium of expression, whether it be a piece of paper, computer hard drive, whatever it may be, if it's got a modicum of creativity and the bar is pretty low, you have a copyright in that work. Now,
okay.
And that's all fine and dandy. That means you're the owner and so on. However, registration of your copyright, it's crucial because what registration does is it gives you some significant advantages if your work is infringed upon. What are those advantages? One, with registration prior to the infringement being initiated, it's prima facie evidence that you created this original work on this date. So that's great because there's half your lawsuit. Okay. Mm-hmm. So, yeah. And then there's two other things that are crucial that you get with registration. One is you can elect to seek statutory damage instead of having to prove your actual damages. As you could imagine, it's not easy sometimes to prove what your actual damages are in an infringement scenario. So instead, I could say, you know what? Instead, I'm gonna go for the statutory damages that are allowed by the Copyright Act, and I'll seek that and dispense with having to prove my actual damages. But the big hammer that you get if you have registration at the time of an infringement is you can get attorney's fees. Meaning, if you prevail, the other guy has to pay your attorney's fees. The court can make that order. The prevailing party gets their attorney's fees paid for by the other party. So when I have a client who has an infringement scenario and he or she has dutifully registered their copyright in it, if I can go to the infringing party and I wave around that registration, that settles pretty quickly
I
in
bet.
general,
Yeah. Yeah.
because they're looking down the barrel of, clearly it's, my guy created it as of a date certain. He's going to get some damages. But the big hammer is you're going to pay my attorney's fees. So the longer this thing drags out, the more you're going to pay. So
Yeah.
real incentive to settle. That's that issue of not having a registration when an infringement occurs. That's the problem. Because you have an infringement, but you got to try to prove your actual damages. You don't get attorney's fees, all those fun things you get with registration.
Okay. So it's still going to be, and when you're not registered, the burden of proof is still on you, obviously, to show like, I did this whole thing and whatever. It makes me think of poor man's copyright, where they used to say, here, put it in the mail and address it to yourself and send it and whatever.
Don't do that. I get that at least once a week.
I bet.
Poor man's copyright is pretty much useless.
Yeah.
I mean, look, copyright registration is relatively cheap. I mean, it's, depending upon what you're seeking to register, it's around $55. And it's, if you've got a modicum skill set, you can do a registration on your own. I always tell people one of the best government websites that I've ever come across, in fact, the best that I've ever come across, is the Copyright Office's website, which is copyright.gov. And if you go there, you'll find a bunch of circulars that will explain to you step by step how you register copyrights for photograph, for literary work, for artistic work, so on and so forth. Walk you through the process. You can file online. It's relatively cheap. And everybody, if you're generating creative output, you should certainly on at least a periodic basis take your output and register your copyrights. For photographers, there's a great thing now where you can register up to, I think it's 750 photographs in one registration.
Oh.
So if you're a photographer, there is no reason for you, that you're not taking advantage of that. Maybe on a monthly basis, you register all the photos you just took, or on a quarterly basis, whatever it may be. So, that's a real benefit, but the benefits of registration are just significant. And, if you're a creative, you need to kind of have an understanding of how to register copyrights and of course, what that gets you, what rights it gets you, and how it gives you a leg up in the infringement scenario.
Yeah. And I think we get to the point, as generally as creatives, we're like behind on this stuff, right? Like we're behind on the copyright, behind on the legal, behind on the accounting, like all of that, because we're focused on the making.
You're creative
and having this,
Right.
Yeah. So having this, being kind of ahead of the curve on this is, I didn't realize that, even because I work with a photographer, I had no idea that you could just, for that bulk, right? Because $55 a pop, you're like, nah, I'm creating a lot, but when you can go do 750 photos for that, fine,
That's That's right.
No, I love that. So in addition to that, you mentioned copyright.gov, you said?
Copyright.gov, great website.
Any other recommendations for tools, resources for anybody that's either bootstrapping or needs to figure out how to do some of this stuff on their own, whether it's copyright, trademark, contracts, anything?
Yeah. I'll give a shout out to my firm's website, Crown LLP. We write a lot of articles on things that are of interest to creatives. Things come across my desk and in a timely manner, I say, I should write something about this because I'm getting phone calls about this. I'm hearing about this, so on. So we have all kinds of articles about copyright, about sponsorship endorsement deals and, what's involved there. Trademark, we've got an article on copyright of fictional characters, music copyright, right of publicity, which is increasingly important now that we have this whole kind of ecosystem of social media influencers. And then we also have on our website a series of FAQs. Again, these are we add to that FAQ constantly because, when the calls start coming in and we start to see a trend of questions, we seek to answer them that way. So, we've got FAQs on business formation, on licensing of all sorts, on copyright, on trademark, on right of publicity. So, if you have a question in this area, I venture to guess that we've probably got an answer to it in our FAQs.
Oh, wow. Okay. Yeah, I had no idea. So go check out crownllp.com, right?
CrownLLP.com. That's right.
Okay. Great. Well, before we wrap here, anywhere else people can find you? I know you're on LinkedIn, right?
I'm on LinkedIn.
Okay. Any other social platforms we can find you on, or mainly your
Um,
website?
I'm out there on other social platforms, but not to a tremendous extent.
Sure.
We're out there. Me and my firm are out there, but I think probably the best places to locate me are on LinkedIn and on our website. Certainly if you're looking for information, go to our website. We do post a fair amount of articles to LinkedIn also, so you'll find some of that stuff there too.
Okay. Well, fantastic. Thanks so much. I really appreciate you taking the time. I know you're super busy, as you know, all of us are, but I know you especially. So thank you so much. I really appreciate it, Owen.
My pleasure, Eric. We'll talk to you soon.